I want to use this comment to make a couple of points. The overarching framework, some will, the substantive ones will be about the paper, but the overarching framework is that we've seen in this conference and more generally in the development of the scholarship of originalism that there are now varieties of originalism. And Tom Colby has done a lot about this, and his reference yesterday to Justice Thomas saying, yeah, academics have been slicing the bologna too thin, it bears on this. One thing that's of interest to me in connection with the development of varieties of originalism is this. I understand one important component of the argument about originalism to be that originalism is an interpretive technique one of whose goals is to allocate decision-making authority between legislatures and Congress on the one side and judges as proxies for the constitution makers on the other side. I mean, or, sort of conceptually, you'd want to find out what the constitution makers originally meant or whatever gets filled in after the word originally, but they're not around, and so we use judges as proxies for them. Now the slicing occurs because it turns out that each variety of originalism is vulnerable to challenges that raise questions about whether that version satisfies whatever requirements there are that make originalism attractive as an allocation mechanism. I mean, this is the easiest way to capture this is to reconstruct in your mind the things that led, I call them normative originalists, to abandon original intention originalism. And the reason was it couldn't be developed in a way, there were challenges to it that the defenders acknowledged were serious enough that it needed to be reconstructed in order to serve this allocation function. Now, I think I have in my notes 3 places where this issue of varieties of originalism and their relationship to the allocation question arise. I may not be able to get to all 3, so I'll do it in the order that I find most interesting. The first is something that I'll call the 1819-1866 problem. The structure of the argument in the paper is, again, paring down quite a bit, is this. The established interpretation of McCulloch is wrong in the sense that it departs from what the opinion actually says and from what Marshall, in his defense later published, says it meant. Now, the paper presents what Jennifer says is a better interpretation of McCulloch. And I guess there are 2 components here I want to separately identify. One is that better interpretation was available in 1866. But 2, and this is what makes the argument, I think, interesting, there were also quite a few people who accepted what I've called established erroneous interpretation of McCulloch. So the next step in the argument is that the better understanding, the better interpretation of McCulloch is the one we should use in interpreting the 13th Amendment's enforcement provision. And this, even though, again, I want to stress, a significant number of the relevant actors in 1866 appear to have accepted the established erroneous interpretation. So just the easiest play, I have this quoted in my comments at some other point, but she quotes, I don't remember whether it's Trumbull or Wilson, but so Trumbull says, what is appropriate legislation for Section 2 purposes is for Congress to determine and nobody else, meaning in this context, Congress and not the courts, and then of the necessity of the measure, Congress is the sole judge. Okay, so that's what these people say. And that's to the extent, the argument is to the extent that that is drawn from McCulloch's understanding of what appropriate means, it's mistaken. Okay. My first question is, what kind of originalism is this? Almost by definition, this is also a little tricky, but it can't be original public understanding originalism, because it seems to me, although there was this discussion yesterday that shook my confidence in this assertion, it seems to me that that kind of originalism requires attention to what people in 1866 understood appropriate to mean, not what appropriate meant in 1791, 1789, or what Marshall meant by appropriate in 1819, but what they understood appropriate to mean. That's particularly true because the paper says these people in 1866 understood the meaning of the word in light of what McCulloch said, or I think more precisely for an original public understanding originalist, in light of what the relevant legal actors understood McCulloch to have said. Now, I just note, as I mentioned, that this isn't a problem unique to the 13th Amendment, as we saw in the comments about the incorporation issue yesterday. Now, not having any commitments to any form of originalism, I'm not in a position to offer an account of an originalism that would resolve the 1866 problem in the way the paper does. But I do want to note that it does seem to me that whatever that form of originalism is, and I'm not saying there couldn't be a form of originalism that would resolve the question as she does, it's not one of the currently standard versions. I don't quite know what it would be, but this is, it's not my church, so you people can figure it out, but not Okay. Second, so here that's the first question. It's the 1866 question. A second question arises in connection with the point, which I take to be correct, that Section 2, as the paper puts it, was not universally understood as an expansive grant of congressional power. And earlier today, there was a reference to the fact that there were Democratic and Republican readings of McCulloch. Again, this identifies a more general question about the contours of the various originalism. For reasons based on the work I've done about the Second Amendment, I call it the 60-40 problem. The exposition of the 60-40 problem is tricky, and I don't want to be saddled with the informal formulation I'm about to use. I think it could be worked out more precisely, but it's actually quite hard to do, and certainly can't be done in a short comment. So the 60-40 problem is this. Suppose that the evidence relevant to determining the original meaning or whatever gets filled in according to the version of originalism at hand, so there's original before it and then there's something that comes afterwards. I don't care what that afterwards is. I'm concerned about the evidence relevant to the original, whatever it is. Suppose it leads to the conclusion that, again, this is the informal version, 60% of the people thought a provision meant one thing and 40% thought it meant another. There could be, I think, a number of originalisms flowing from different answers to the question, what do we do in the face of a 60-40 problem? So there's this Democratic versus Republican interpretation of McCulloch. They're both there, they're both available. Let's say, Democrats had lost, Republicans were in charge. Let's say the balance of the evidence supports the Republican take. What do you do when there's not universal agreement? Now, I'll sketch a couple of possibilities. I think the first, and I think the one that most people are attracted to, is that you go with the 60. Now, I'm just going to assert here something that I think I could defend in more detail, that tying that resolution to the normative basis for originalism or for originalisms is quite tricky. Because, somebody yesterday was talking about popular sovereignty. where you have a 60-40 problem, the notion of popular sovereignty comes under pressure. And I think that's going to be true with respect to almost every, maybe all, normative defenses of originalism as this allocation technique. Second possibility is to say that in a 60-40 situation, and this was referred to earlier today as well, we can say that we should treat the provision as kicking the can down the road, or more elegantly, as leaving the choice of how to interpret the provision to democratic majorities in the future. In a 60-40 situation, the allocation is to democratic majorities in the future. Now, I will note a third possibility and then get to my final point, which is unfortunately common. And that solution is to misrepresent a 60-40 situation as a 90-10 one. And when you get to the 90-10 situation, going with the 10 is going to seem quite attractive and maybe correct if you have a 90-10 situation and some popular sovereignty idea. We're not dealing with a unanimous consent kind of rule, but when it gets to be really substantial, the people get to prevail. I alluded to this yesterday in saying that McDonald is at least a 90-10 case, so it doesn't really matter, whereas Heller is, in my view, more like a 60-40 case. Okay, now finally, I want to note an issue about how to treat evidence. It's quite clear from the paper that some people, Trumbull and Wilson quoted, explicitly said that they understood the enforcement provision to use appropriate in the way the established but perhaps erroneous understanding had it of the necessity of the measure. Congress is the sole judge. Now, this raises questions again about original public understanding, because public understanding statements about meaning should be taken as evidence of, not conclusive on, but evidence of public understanding of meaning. But the paper says in several ways that we should discount these comments because they were hyperbole. And in a similar vein, at one point she says that Marshall himself did not heed his own words. Now, that seems to me, I have the word problematic in my notes, but what I really mean is that if you're going to treat these words in that kind of way, you need a, I want to call it, theorized account of how that connects up with originalism. I can understand saying, for example, and we had some discussion of this earlier today, that Trumbull and Wilson were deceptive. That is, they knew they were misstating what McCulloch meant. And we had some suggestions about how you deal with deceptive statements. But if the assertion was that they were deceptive, you want some evidence that they were. It seems to me that an originalism that licenses a judgment that a statement is hyperbolic rhetoric is, again, a non-standard version that needs some defense. Hyperbolic with reference to what? I mean, that's sort of the question. These are, if it's not deceptive, these are things the folks said. And, okay. It might be that the discounting is the result of some resolution of the 60-40 problem, whereby the hyperbolic statement gets put into the 40 category, the minority category. But it seems not to be true about Trumbull and Wilson, who seem pretty clearly to be in the 60 group. Okay, so just to conclude, what I find, this is not, originalism is not something I have any commitment to, but what I find interesting, most interesting about the paper is the way in which it opens up questions about what I called at the outset these various varieties of originalism. Thank you.